all water rights have a priority date. That's when the water was first put to use. So there's a priority date, and that is key. It's the foundation for priority distribution within the state of Utah and how we determine on a limited supply where the water should go and how it should be used. Every water right has a point of diversion. You see all these elements on this slide. Point of diversion, so we know where the water is being taken, so we can tell and understand if an existing right holder is going to be impaired. There's a place of use, nature of use, period of use. Oh, there's an owner, quantity of water, there's a diversion, and there's also another key component to all water rights, which is depletion, which is the amount of water that's removed from the hydrologic system by a water right, and that is another key limitation of a water right. And sometimes these water rights also have storage. So a lot of very basic elements that define a water right within Utah. I'm just going to talk just a little bit here next about some approval criteria. Not all water rights are approved. Most of the state is fully appropriated, as you can imagine. There's already existing rights. There are some open areas, and actually to limited amounts, and we actually happen to be in one, which is right here in the Uintah Basin. So some of the approval criteria, let me just talk about what we have to look at when a water right application comes before the state engineer. And statute, actually, Utah Code says that it shall be the duty of the state engineer to approve if, that's a pretty positive statement. It doesn't say shall reject, it says shall approve if. So we weigh this criteria with every application, whether it's a new application, a change application, whatever it is, we use this criteria to evaluate the applications. So is there a reason to believe? That's a standard that's well established, it's established in statute and well established in case law. That is there a reason to believe that the project can be done? It's a pretty low burden for the applicant because it's a reason to believe. It's not like a preponderance of the evidence. But is there a reason to believe it can be done? We also look, is there unappropriated water in the source that can be appropriated? And then also, like I mentioned previously, will it impair existing rights? If there is evidence that it will impair these existing rights, we can't approve the application. We also have to see that it is physically and economically feasible under the application, and it's the applicant's burden to demonstrate that. Some of the other criteria, that it's not detrimental to the public welfare. This is a broad public welfare. I think that there's been some efforts over the last few years to try and define what public welfare means under these applications, but the statement right now is just not detrimental to public welfare. We also look at the financial ability to complete the proposed works. Does the applicant have the financial means to do the project? And one important one as well is the application filed in good faith and not for purpose of speculation. If it does appear to be a speculative application or an attempt to monopolize on the public waters, we do have to question that, or the applicant has to demonstrate how it's not speculative what they are doing. And then it has to comply with groundwater management plans. There is in Utah Code the authority of the state engineer when it is a critical management area for groundwater, that we can adopt what's called a groundwater management plan that basically directs users with water rights in a particular basin to cut back their use to stay within safe yield of the basin. One of the maybe differences, and I'm just gonna put this out there, that one of the differences between managing water within safe yield and perhaps drilling for say oil, is that with water, we are trying to stay within that safe yield. What is the recharge of the aquifer? Do we know what that is? In some cases, we do. Utah does lag behind on our resources for modeling with groundwater. It's pretty hard, all of you know, it's pretty hard to see what's under the ground, right? Same applies to water, and Utah does lag. I know I just had a conversation with the New Mexico State engineer, and they have extensive groundwater models that help them determine connectivity between groundwater and surface sources or from well to well. They employ about 18 to 20 hydrologists that do their modeling, and they have a budget in addition to that of about 5 to 10 million a year to do characterization and drilling to inform those models. We've got a long ways to come in Utah, and so hopefully that's something that the state can look at doing over the next few years, is just really getting more information on our groundwater. Let me talk about some application types. I was up here, I was standing in the back when the previous group was up here, and they talked about communication and collaboration and what can be done with some of this water that is being used. And so what I wanted to talk about just for a few minutes is potential solutions that are currently in water law within Utah that could maybe help forward some of these efforts that they talked about. There's many types of applications. Some of these are newer that had been adopted in statute within the last 2 to 5 years. There's applications to appropriate. That's only in an area where there's water that can be appropriated. And like I mentioned, most areas are closed. They can be a permanent application. You can do a temporary application to appropriate, which is just for 1 year. Or you can do a fixed time appropriation, which can be 10 years and then extensions on top of that. This area is still open to fixed time appropriations. You also have the ability a tool to file change applications on existing water rights within the basin, and those can be permanent. 2 years ago, we added fixed time, which is for greater than 1 year or less than 10 years, with the ability to file extensions on those. Temporary change applications, which are 1 year applications. And then there's also a split season, which we have yet to have a split season application filed, but it is a tool that we have within the current water rights system. All of these could be used in various applications within the Uintah Basin on state-based rights. So let me just talk about some of the existing water rights, state-based water rights that we do have in our database right now. There's hydroelectric for energy development, geothermal, which is a big industry. One of my folks oversees the geothermal regulations within the state of Utah. Steam generation is another one. We also have industrial, which would be an application type that some of the energy water rights are listed under. There's mining, of course, commercial, which does cover some of the energy development rights as well. We also have some water rights for oil extraction and oil recovery as the beneficial use that is currently under water rights within our system. So I talked about subject to existing rights. So any decision of the state engineer does have administrative relief through what's called a reconsideration. So an applicant or a protestant to an application can seek administrative relief if they feel that either their application was rejected and the state engineer didn't consider the information that they felt should be considered, or if it's a protestant that has an existing right that feels that they're going to be impaired. So there is administrative relief. There is also, if that isn't granted or done, a party can seek a de novo review of the state engineer's decision through district court. So the state engineer doesn't have a board, a special interest board. It's a person, which is me, and those decisions are made and issued, and then we have administrative relief or review by the court of those decisions. And a lot of court precedent or legal precedent has been set through many decisions over the years by legal means. And there are some legal precedent that's been set even with energy development type rights or mining rights. So I talked about some considerations. When we consider existing rights, it's not just looking at an application or a water right that exists on paper. You know, we do have to consider prior rights. We have to look at priority distribution, compact compliance, whether it's the Colorado River Compact or the Bear River Compact. Those are two interstate compacts that Utah is party to. Legal precedent, like I mentioned, many directions that are taken in decisions are because of legal precedent set by court decisions. You have state-based rights, and you also have Federal Reserve water rights that exist and need to be considered as well. A lot of these are established for tribes, so you have that here in the Basin, but you can also see Federal Reserve for Forest Service or parks, national parks, reservation. With any change application, we can't enlarge the water right, so you can't increase depletion or diversion in that change that you're making. We have to look at the safe yield of the aquifer. More groundwater studies would really help us understand that, but that is in statute, and we have to consider that when we manage groundwater. And then I just throw out this groundwater and surface water connectivity. All water is connected in some manner, and we really have to be careful when we approve groundwater rights that they're not detrimental to surface flows because we know that connectivity. We have had that throughout the state, and we have to be careful that we don't impair those existing rights. So really brief, they gave me like 15, 20 minutes to cover water rights, which in itself was a challenge. So hopefully just staying with the basics kind of gave you a little brief introduction of what I have to look at as the state engineer and considerations. I do believe communication and collaboration and the current water right system we have, there are some tools that can help forward a lot of what is happening out here in the basin. So with that, I'm in the red now, which usually means I'm done. So with that, I'll conclude, and I'm happy if there's time to take a question or two or turn over to the next speakers. I'm looking for, where's Travis? Somebody. Oh, let's take a question. Oh. Can I reply to that? I don't know if you heard. He is with the Ute Business Committee and had an issue with the first slide, which is all waters are public. That is from Utah Code and applies. And as I mentioned in one of the last slides, there's definitely a body of law for Federal Reserve water rights that also have to be considered. Yep. Yeah. Okay, thank you. I don't know if I need to repeat that, or did you hear? Okay, Anything else, or should I turn it over to the next group? Who's coming up? Okay, here they come. Thank you, everyone.